Hello, welcome back to Marriage Practice and Procedure in Exile. This is video 3. Now, the lesson we're on is lesson 8, which is on the formal process, the formal nullity process. However, you see that I've got here plus lesson 9, Mitis Iudex. Lesson 9 it's a separate lesson, but we almost need to do them together um, because there have been some changes in the process because of Mitis Iudex. As you'll remember, Mitis Iudex is the 2015 reform of marriage law by Pope Francis. So it just wouldn't make sense to tell you what's in the code for lesson 8 and leave you with a false impression without telling you how that has changed with Mitis Iudex. So this video will be mostly on lesson 8, but we're going to have to dip into lesson 9, and then the next video, similarly, will be uh, pretty much both on lesson 8 and lesson 9, but probably more of lesson 9, more of Mitis Iudex there. Okay, our main text for this lesson is our readings in Woodall, uh, pages 495 to 517 in chapter 8. Remember, just from our whole semester, the distinction between judicial processes and administrative procedures. Now, if there's a dispute about how a leader in the church exercises his administrative authority, who he appoints, what he does with the with church property, um, what decisions he makes in the parish or in the diocese. Nearly all cases about disputes like that are handled as administrative cases or administrative procedures. Uh, as a result, the we get this lopsided judicial system where almost the only type of case that is adjudicated in the judicial process is the marriage nullity case. Penal law would be an exception. We also have penal processes, and there are other types of cases that occasionally take place as a judicial trial, but overwhelmingly the judicial process or judicial trial in the church is concerned with marriage nullity. So that's just kind of a strange feature of our system. However, even in marriage, as we've seen this semester, their administrative procedures are important. Um, and we've seen some areas where administrative law comes into effect. For example, we've just talked in lesson 7 about the favor of the faith. That's an administrative procedure. We talked about the Pauline privilege. That's sort of an administrative procedure. We had, I think in our last class, or the class before, a pretty interesting discussion of the separation of spouses, especially as it's done in Asia. That also would be an administrative procedure. So even though when we think of marriage cases, we're thinking primarily of the judicial process, there still are administrative procedures that concern marriage. Okay, to start out, one of our basic principles about the judicial trial, or really just about the church being involved in these cases. Why is the church judging cases about the nullity of marriage? Well, the church claims an inherent right to judge spiritual matters that involve the violation of ecclesiastical laws. You can find this principle in Canon 1401. And needless to say, marriage is a spiritual matter and it involves the law as well. Okay, one of our first, I should say that in this lecture, we're going to be talking about a lot of the institutions involved in a judicial process. It'll probably be more in our next lecture video 4, where we talk about how the trial actually proceeds. Our first big question is the question of competence. What is the competent forum? Or what's interesting in church law, sometimes there's more than one forum that might be competent. If you're following along in Woodall, this is discussed in Woodall in page 496. What do we mean by competence? You know, in our ordinary language, when we say someone is competent, we say that he's able, he's skilled, etc. We're talking about competence in a different way. Here we're saying which court, which tribunal has essentially the right to hear this case, or which group of tribunals have the right to hear this case. So in a sense, even though the church calls this idea competence, it's more like jurisdiction. Who has jurisdiction over this case? Again, it could be more than one tribunal. You might have a choice of 2, 3, or even 4 places, but they all have to have a reason that they are a proper tribunal. Okay. Let's see, if you have a case involving the like a head of state, a prince, or even a president, those cases are not handled in an ordinary tribunal. Those are handled by the Roman rota. And Woodall discusses this on page 497. On 496, he makes a mistake and he says the Roman pontiff, but he corrects that on 497 and says it's the rota that deals with these cases. So that would be something that would be removed from your jurisdiction. So if the governor of the state filed a petition, he would that would be a case that should go to the rota. What other cases are reserved to the Holy See so that your local tribunal could not hear them? Well, we've talked about some of them, even though these are administrative matters. Non-consummation cases where you're looking for a dissolution, that is going to be a matter reserved to the Holy See. And the cases we just finished discussing in Lesson 7, favor of the faith cases, also are reserved to the Holy See. They may be prepared at the diocese, and tribunal personnel might even be involved in helping get those cases together because they're skilled in marriage matters, but the actual decision is going to be made by the Holy See. Okay, but for other cases, if you have someone that wants their marriage declared null, and they're not a head of state or someone whose case is reserved to the Roman rota, there's a basic principle for what the competent forum is. And you can find this in Canon 1407, Section 3. And to understand this, we need to keep in mind the two basic parties, the petitioner and the respondent. So the petitioner is the person who's putting forth the petition, who says, I want this marriage declared null. And the respondent is the other person, the other party. So the respondent may agree and say it's fine with me if it's declared null, or they may say, no, I'm going to defend the validity of my marriage. So we need to know these parties. So needless to say, a husband or wife could be either one of these parties. Either the husband or the wife could be the petitioner, and then in that case, the other one would become the respondent. So you can't think of just the husband as the petitioner or the wife as the respondent. It could flip. the basic principle, and again, this is in Canon 1407, Section 3, is that the petitioner follows the forum of the respondent. What does that mean? That would mean if the petitioner and respondent were in different places, the petitioner's in Evansville and the respondent is in Mobile, then this basic principle, this basic principle would say the petitioner should sue the respondent in Mobile. Why? Basic fairness. We're concerned especially with the fairness to the respondent. We want to be fair to both, but the petitioner is the one who's initiating the process, who's getting the legal process in motion. So we're more concerned about the respondent, especially in marriage law, because the respondent may be absent, so that his or her rights are protected. And one way to protect his or her rights would be to say, hey, petitioner, you need to sue where the respondent is living. Now, keep that in mind as a basic principle, a foundational principle. In reality, we may see something different happen. This is an important area. This idea of the competent forum, where we're going to have a big change with what happened in Mitis Iudex. The best way to understand it is to look first at the old rule, and this would be the rule that's in your code of canon law. Now you should have an insert there too, and the insert would say something different. The insert will reproduce what Mitis Iudex did, or if for some reason you don't have an insert, you can get that in the Scholar Shop, or you can get that online too. But here's the old rule. So keep in mind what I'm about to tell you is pre-Mitis Iudex, so pre-2015. The old rule was found in Canon 1673, and that canon gave the petitioner 4 options of where to bring the petition. First, he could bring the petition in the diocese where the marriage took place. That was, well, what if that's far from what if the respondent doesn't live there anymore? Say they got married in New Orleans, and the petitioner says, I'm going to bring the petition in New Orleans, even though the respondent lives in Mobile now, and I, the petitioner, live in Evansville. Why could the petitioner sue in the place where the marriage took place? The idea is that, well, the petitioner established contact with New Orleans by getting married there. So it's fair to say that if a case arising about your marriage is brought in the diocese where it took place, it's fair to have you answer there. Whereas, let's say they've been apart for 5 years and it's only recently that the petitioner has moved to Evansville. Is it fair to make the respondent answer in Evansville? We'll see. The old code would say no. The code as originally written would say no. That's not fair. Okay, so one option was sue where the marriage took place. Another option was, following the big rule, follow the forum of the respondent. Sue where the respondent lives. Respondent lives in Mobile, sue in Mobile, or petition in Mobile. Okay, there was a another option. A third option was to bring the petition in the diocese where most of the proofs were located. So what does proof mean? The proofs mean the evidence. So that would mean, are there relevant documents, more likely relevant witnesses? Let's say both parties grew up in Chicago, and the petitioner wants to sue in Chicago because all the witnesses are there. If we need to go and talk to them, they're all in Chicago. That would be an argument for being able to sue in Chicago, because the parties are from there, and that's where most of the evidence is located. So that was another option. But in that situation, the again, this is under the old law, the 1983 code as originally written up to 2015. But the respondent's judicial vicar, now again, our respondents in Mobile, the respondent's judicial vicar had to consent to the case being brought in Chicago. So again, now that's our third option of where to bring the petition under the original code. We have one more option. Sometimes the petitioner could sue in his own diocese, but if he wanted to do that, what he could only do that if the respondent lived in in the same country, basically the territory of the same conference of bishops, and if the respondent's judicial vicar again consented. So here we're going to say consented to the petition being brought in Evansville. Okay, so we have those four options under the original code, Canon 1673. Okay, let's look and see how Mitis Iudex changed things. Our first place that we said you could bring the case if you're the petitioner was in the diocese where the marriage took place. That's the same. You can still do that under Mitis Iudex, so there's no change there. Okay, now though, what the also under Mitis Iudex, the now there's really just a second option, and the second option is that the petitioner can sue in the diocese where he lives or in the diocese where the respondent lives. So the petitioner now has a choice of being able to sue in his own diocese, Evansville, or in the diocese of the respondent, Mobile. This is a big change, and some people would say it seems to disregard the basic principle of 1407. Remember, that basic principle is that the petitioner follows the forum of the respondent. And also keep in mind, under the previous code, under the current code, but as originally written, Canon 1673 said that sometimes the petitioner could sue in his own diocese or in the diocese where the proofs were located, or where most of the proofs were located. But to do that, he had to have the consent of the respondent's judicial vicar. Now he no longer needs that consent. He can just freely sue in his own diocese. He's no longer limited to having a special need to sue in his diocese. He can just decide freely. By the way, the canon on competence also shifted. It used to be Canon 1673. Now, under Mitis Iudex, it's Canon 1672. Mitis Iudex changed about 20 canons, and the canon numbers are usually close to the same, but they can be off by one or two or three. So here we're just off by one. Okay, that is, again, that's a pretty big change, because it does not, well, is it good, or is this a good change or a bad change? Like so many of the things we've talked about this weekend, it really depends whose case you have in mind. If the person you're concerned about, or the person you are, is a petitioner who wants a quick, convenient nullity decision, this is a very good change, because now he can sue in his own diocese. Like, hey, I can bring the case right here in Evansville. I don't have to find a canonist in Mobile or contact the Mobile diocese. I can just bring the case here in Evansville. So if you've got the petitioner's point of view in mind, this is very convenient. But if you're the respondent, or you have the respondent's situation in mind, or you want to defend the validity of the marriage, you may not like this change because now the respondent has, in a way, really lost some of the protections that he or she had under the original code. Um, it used to be that the petitioner had to sue in the place of marriage, had to sue where the respondent lived, or if he wanted to sue in his own diocese, he had to have a good reason and had to have the respondent's judicial vicar's approval. Now the petitioner is much more free to sue in his own diocese. So, uh, in a sense, less of a protection for the respondent. Um, why does this matter? One thing is it's just more costly to have to, for the person in Mobile to have to respond in Evansville. Now he or she is the one who may need to obtain help. Uh, they don't necessarily have to hire their own lawyer, but again, they may want to travel and be present for the examination of witnesses, which may take place in Evansville now rather than Mobile or rather than New Orleans, where the marriage took place. So definitely, this is a change that really favors the petitioner. Okay. Um, Now, remember, you're writing your main writing paper is going to be about the changes of Mitis Iudex, and this would be one of the rather significant changes. So it would be one that you probably should address. There are a couple of very big changes, and then some more small to medium changes, and you should be addressing at least 3 or 4 of the changes, especially the major ones. Okay, let's go on to a different question. Again, we're really talking here more about how tribunals work than what the process itself looks like once it's up and going. That's more what we'll talk about in the next lecture. Uh, if you're following in Woodall on 497, he talks about what's called grades or instances of tribunals. I think we've discussed these in class already, but this is something that we should at least review here. And the first thing to know is that we're talking here about in part about first instance and second instance. The place where you bring your case. We're talking about a petitioner from Evansville. Maybe he'll be suing in Evansville now or petitioning in Evansville. The Evansville Tribunal would be the first instance tribunal. Now, the old law, the 1983 law until 2015, said that let's say Evansville rules for nullity. Evansville gets the case, they rule for nullity. The that judgment does not go into effect until it's confirmed by a second tribunal. Um, and usually that tribunal would be the metropolitan, so it would be Indianapolis for Evansville. So just because you've won at Evansville doesn't mean that you get to marry again. You have to have the Evansville sentence confirmed at Indianapolis. Or if the petitioner wanted to, they could appeal to the Roman Rota as well. That would be pretty rare, but it is possible. This idea of having to have a second sentence coming out the same way, that's called a concordant, CONCORDANT, a concordant sentence, concord. The second sentence agrees with the first. Not only does it agree that the marriage is null, but it agrees on the same ground too. It agrees that it's null for on the grounds of, say, consanguinity. They were too closely related, something like that. Um, this rule of needing a second conforming or concordant sentence, this goes back to 1741 and Pope Benedict XIV. So a very long-standing. It was considered very much an advance in kind of canonical procedure. Now, in the original code of 1983, you found this requirement in Canon 1682. However, Mitis Iudex, in a new canon, then the new canon is 1679, changed this. And this is a very significant change. This is one of the most significant changes that Mitis Iudex made. And what it said is that unless there's an appeal, it's okay to act on the first tribunal sentence. You don't have to wait for the second tribunal unless someone appeals there. But if neither party is dissatisfied, remember sometimes both the petitioner and the respondent both want to have the marriage declared null. If nobody appeals, then the first instance decision goes into effect. So basically this idea of needing a second concordant sentence, or that was also called the automatic appeal, meaning that you needed that second court to find the same way before you could actually marry again if you were the petitioner. Now Pope Francis has said you don't need that automatic appeal or that second, that concordant sentence. So this is, again, a very big change, one of the biggest changes that Mitis Iudex makes. Okay, again, our same question. Is this change wise or is it unwise? Really depends on your perspective. It's gonna depend. Your perspective might change over time depending on who you're working with. If you're talking about say a petitioner who wants to move on from a very unhappy marriage, you're probably going to be very happy that the um, the process has been speeded up because you don't need this automatic appeal anymore. That's going to save you several months. However, let's say you're counseling the respondent who's been abandoned and who thinks that her marriage is still valid and wants to defend it. You might feel very differently about the abolition of the automatic appeal, because the automatic appeal is going to give additional certainty that the right decision is reached. Without that, it might look to you, especially if you're on the side of the respondent, like we've gotten this decision too hastily, and we don't have the safeguard of making sure it's the right decision because we're not requiring the automatic appeal anymore. This is somewhat sadly like some of the other things that we've discussed this semester, like convalidation and favor of the faith cases, where we've got this very difficult decision to make. What should the church's policy be? What should the law say? And it seems whichever side you come down on, somebody is going to be hurt by whatever decision you make, or whatever decision the church leadership makes. So just a real challenge in several areas of marriage law, including this one. Okay, let's move on. We're still talking about the judicial process. Let's talk a little about tribunal officials. The norm, and this is in Woodall at 498, the norm is that the tribunal should have 3 judges, that it should be collegial, not just a single judge, but a college of 3. Usually 3, sometimes a college of 5. But the norm is that there should be a collegial tribunal of 3 judges. Usually the judges were expected to be priests, but one could be a layperson. The original 1983 code, it allowed the use of a single judge to judge the case, but only if the Conference of Bishops had allowed this, either to all of the bishops in the territory or to different bishops individually. Again, we're going to have a change with Mitis Iudex. Now, the diocesan bishop himself can decide to entrust a case to a single judge. He no longer needs the approval of the Conference of Bishops. And uh, some people think this is going to become the norm of having cases judged by a single judge instead of a collegial tribunal. Why does this matter? Again, it really is going to depend on what your priorities are. One of the things that a collegial tribunal, why was this the norm? Why did the law seem to prefer this? To give some additional certainty by having three judges review the case, not just one. Now, with the changes of Mitis Iudex, many expect that now it's going to become much more common and even the norm to have only one judge reviewing the case. And remember, we've canceled the automatic appeal, so the judges who would have reviewed it there aren't reviewing it anymore either. There may only be one judge who ever sees the case. So again, you'll have to think in writing about Mitis Iudex, is this a good change? Is this a bad change? And it's fine to have a perspective, but you'll have to decide what you think is most important. Is it most important to have these cases move along quickly, in which case you'll probably like these reforms, or are you more concerned with protecting the rights of the respondent and making sure that the decision is correct? If those are your priorities, then you may say that things like the automatic appeal served a very good purpose, and the collegial tribunal as well. Okay, let's see, a few things just about what Woodall calls the discipline of the tribunal. This is at page 500 and 501. He says the accused in a penal trial must have an advocate, but this is not true in a marriage case. He's correct about this, and he cites Canon 1481, Section 3. But if you look at Dignitatis Connubii, Article 101, it tries to strengthen the presence of advocates, and it says that if the case is particularly difficult, the tribunal needs to ensure that there's an advocate, and it needs to make sure that the right to defense, especially of the respondent, is protected. Okay, one final thing on page 501, Woodall talks about what he calls, or not what he calls, what the law calls exceptions. Page 501 of Woodall, exceptions, EXCEPTIONS. What's an exception? It's like an objection. If you've watched court movies when somebody objects, that's pretty much what an exception is. What might you take exception to, or what might you object to? One thing would be the competence of the tribunal. This tribunal is starting to hear the case, and you say, no, this is not a competent tribunal. None of the parties lives here, and the marriage didn't take place here. This is not a proper place to bring the case. That might be one reason you would object. And another reason you might object is that the forum is okay, the place is okay where the case has been brought, but there's a problem with the specific judge. This judge is the brother of the petitioner, and so has a conflict of interest and should not be allowed to hear the case. So you might take exception to either the qualifications or the impartiality of the judge who's deciding the case. Okay, that's really the end of this video. We're going to pick up again, continuing to discuss Lesson 8, but also discussing more of Lesson 9, the specific changes of Mitis Iudex as well. Thank you very much.